despite this man testifying that William wanted to hire him to kill his wife, this whole claim that she then dies by suicide.
And Jeanette, you and I have heard a lot of defenses here on Law and Crime, but this one really takes the cake. You have a criminal defendant who's saying that his wife strangled herself. I mean, of all the ways to kill oneself, not that she strangled herself, when she did, he covered the sheet so their children wouldn't find her. So really poor defense here by a pretty terrible person and a terrible defendant. So I'm not surprised. There's so much evidence implicating him in this case. And I think this is one of those defendants, unfortunately, that's gone off the reservation. First wanted to defend himself, now didn't want to be present in the courtroom, but wanted to watch from a remote location in the jail. So I fully expect a guilty plea in this case. The jury is going to see right through this really terrible
That
argument.
much money at the casino, and then you ask this man to kill your wife so you can get a life insurance payout. This seems like a very crucial witness for the prosecution.
Yes, Anjanette, and it's never good when your friend is testifying against you in a criminal case. Not only is he testifying to motive, which in this case is that $400,000 life insurance policy and, you know, the gambling problem, but really telling the jurors that he solicited you and asked you to kill his wife. And when you said no, asked you to find a hitman for him. So this is certainly one of the prosecution's star witnesses. Very important testimony, very powerful testimony. I thought he came across very credible. And I really like these new clear masks that prosecutors and a lot of attorneys in states are using, so you can really see the witness's mouth, even though, you know, he or she is masked up.
But this seems very, very damning, to say the very least.
Yeah, what motivation would a friend have to testify and get up before that jury and perjure himself and come up with this really sort of fascinating story of a hitman? And let's not forget that the defendant in this case, after his wife died, he tried to kill himself and then ended up at Foxwoods Casino. So everything, all the evidence in this case is consistent with someone who has a very serious gambling problem, who wanted to kill his wife because they were going through a separation, and they consulted divorce attorneys. He'd actually contacted law enforcement because she feared for her safety. And now you have this witness, independent witness, third-party witness, actually friend of William, Jim, who's coming in here and really putting all the pieces together for this jury. So this is not good testimony, and really one of the many reasons why I expect to get a conviction in this case for the state of New Hampshire. I'm sure we're going to be talking about it. Very different from William Argie, which is a slow march towards a guilty verdict. I mean, Kim Potter is going to be a much more difficult case. Obviously, we know that jurors, they love law enforcement, but you know, and this is actually the second trial ever in the state of Minnesota to be televised. The first being, of course, Derek Chauvin. Judge Chu initially said no, but she reversed her decision. So let's talk about what kind of jurors the defense is going to want in this case. And they're actually what prosecutors normally want. They want older, more conservative, white jurors, pro-law enforcement jurors. They don't like woke jurors that are sensitive to issues of systemic racism and want to reform our criminal justice system. Those are pro-prosecution jurors in this particular case. So it's not surprising that this particular juror was kicked off by the defense.
When you contrast it to the Chauvin case, which it seemed to take longer, I think that took it might have taken a full 2 weeks, if I recall correctly. And this one seems to be moving more quickly. They're getting more of those, you know, the final pool together. So are you surprised by that? Because I feel this is high profile, but maybe it just didn't catch fire like the Chauvin case did, especially since that video of George Floyd, it went on for so long, and this was more of one of those split-second decision type cases.
Sure. I mean, George Floyd was obviously something that caught the entire world's attention, you know, the knee on his neck for almost 9 minutes. Obviously, it's a very sad and tragic case. You know, this is your sort of typical either manslaughter, depending on if you're on the prosecution side, or a mistake if you're on the defense side. You're not looking at murder like Derek Chauvin did, just that continuous decision. But a lot of it also depends on the judge and the attorneys. You know, obviously a very different set of folks in the Derek Chauvin case, the judge ended up granting additional peremptories. You would also hear the attorneys ask questions for, you know, minutes at a time, sometimes even hours, and then ultimately end up dismissing the prospective juror when you knew that was going to happen all along. So credit these attorneys for moving quickly. I mean, you and I saw that this particular prospective juror was going to get the boot. So the defense attorney didn't waste any additional time, asked the court to thank and excuse her.
She feels kind of nervous in, the presence of authority figures. She's not so sure. She feels, that police make her feel safe. Did you expect him to maybe go a little further with that?
No, Anjanette, because I see how the defense likes this juror. I think the prosecution is out of strikes. I need to double check. So, I mean, we're really kind of waiting for the defense here right now. And this is the type of juror that, at least from what we've heard, is not going to rock the boat, likely going to go along with the rest of the panel. And you don't want to have too many leaders or too many strong personalities in that jury deliberation room. So jurors like this, a mix of this type of juror and folks that might be the foreperson or might lead the group, is really what you want if you're the defense in this case.
It's kind of wild to me to watch kind of similar players coming into the courtroom in this case. The Attorney General's office, they're all sitting there. They were in the Chauvin case. Now we've got Earl Grey also involved in the Floyd case. So is that interesting to you to watch this? It's almost kind of like a redo.
It's fascinating. Gray is representing Lane, who is obviously one of the officers involved in George Floyd's death. So it is a small panel. Some of that evidence came in outside the presence of the jury during the George Floyd case. And it's very interesting. I mean, obviously, Keith Ellison, the attorney general there in Minnesota, has taken over the prosecution of these two cases, did an outstanding job with Derek Chauvin, Kim Potter. Kim Potter is going to be a tough case. I mean, we've learned a lot about Minnesota in terms of how these cases are handled. We talked about cameras in the courtroom. We talked about this panel of attorneys that represents police officers. But there's very unique things about Minnesota law. It's in some ways a minority jurisdiction. We saw some of it with Derek Chauvin, that third-degree murder, that depraved heart. It was litigated, went up on appeal, the Muhammad Noor case. Ultimately, it ended up not mattering because Chauvin was convicted of the higher count, second-degree murder. But in this particular case, Minnesota has first-degree manslaughter, which is something that a lot of states don't have. Yeah, and Jeanette, with friends like this, William is in bad shape. He's got to get a new set of friends because they're coming up one after another, testifying against him and helping the state of New Hampshire get that guilty verdict. I mean, they're testifying about the bad relationship between William and his wife, the victim who was killed, talking about the separation. The violence within the household. That's not what you want if you're Williams' defense attorneys in this case. Two important points here. Obviously, the defendant has a constitutional right to remain silent. We expect him to testify because of he's been sort of running the show in this particular case. So we'll see if that happens. But if not, this is good for the prosecution for two reasons. First, you're getting the defendant's statements in through another witness if he doesn't testify, and they're not good statements. And importantly, this is the second friend, Anjanette, who called law enforcement on the defendant, apparently, purportedly their friend. So not helpful when you're on trial for murder and two of your friends are calling the police on you.
You don't have to pull it that hard to make the gun fire. So what were your thoughts on what Steve had to say?
Yeah, I loved what Steve had to say, particularly he questioned why Alec Baldwin would even give this interview. And I know Aaron Dyer, who is Alec Baldwin's attorney, he's one of the best. We used to work together. He's also a former federal prosecutor. So I'm sure there's a non-legal reason for him doing this, probably a PR reason. As a defense attorney, the last thing you want to do is have your client give an interview like this. But I'm sure he prepped him, and we'll see how it transpires this evening. I'll be sure to watch it. Now, with respect to any criminal charges against Baldwin, there's a few bases. That gun, apparently, there are reports that it did misfire the Saturday before Helena Hutchins was killed. So misfiring is a possibility. And it's interesting to see what Alec Baldwin says. He said he didn't pull the trigger, but maybe his finger was on the trigger and he was pointed the weapon. It was pointed at another human being. So those are bases for, that criminal negligence, that recklessness. I mean, there's a way that you can be responsible for someone's death, even if you don't intend to pull that trigger. So his words tonight, Alec Baldwin's, are going to be critical to this investigation. Even if you believe, you're told by Dave Halls, you're told by Hannah Gutierrez Reed, that it's a cold gun, that there are blanks in the gun. You should not have your finger on the trigger under any circumstances. You should not point a gun at another human being, even if you believe that it's cold, it's loaded with blanks. So there are potential bases, certainly civil liability, no question, but even criminal liability. So Alec Baldwin has to be very careful in what he says this evening because it could be used against him in a subsequent criminal prosecution, if any.
With William Argie testifying, kind of in layman's terms, explain that to us.
Yeah, I mean, the defense is trying to keep out these statements. There's two types of privileges. There's a marital and spousal privilege. I'll just kind of go through them real quickly. The marital privilege protects confidential communications with your spouse. The spousal privilege prevents the government from forcing your spouse to testify against you. Well, in this particular case, William Argie's spouse is deceased. With respect to those confidential communications, the defense is trying to keep them out. Again, trying to keep out any harmful statements that the prosecution may use against the defense in this case. Yeah, there's two reasons why defendants testify. One is the defense attorney has no control over them, which may be the case. Or two, the case is going so bad that you just basically throw a Hail Mary and hope that you can pick off one or two jurors with the defendant's testimony on the stand.
Really excited about doing so. I thought it was interesting. They were going to get her a gluten-free lunch, so that's good. So she'd be able to eat if, she is selected. So what are your thoughts on this particular prospective juror?
And Jeanette, this is another one of those go with the flow jurors. She's not going to rock the boat. She said she's willing to serve, but doesn't want to serve. She's concerned about her safety, her information being made public. I didn't understand the whole fraud angle, but maybe she's been the victim of identity theft or some other fraud. So again, this is the type of juror that is probably going to be good for the panel as a whole because she is unlikely to be a leader, nor is she unlikely to hang the jury or be a holdout.
Really, really love to know what they're talking about in this sidebar. It doesn't work that way, though. So we're probably not going to find out, at least not until the end of the day. I'd love to be listening into that. What could be coming up with the judge? The judge is the one that asked for the sidebar. Why would she do that? I know you'd just be speculating, but I'm wondering your thoughts.
Sure, it's the end of the day. The parties are running out of peremptories. Again, I think the state is done and the defense is running out. And I know originally Judge Chu wanted trial opening statements. Well, trial started obviously, but opening statements to start December 8th. So sometimes what you do when you're down to your last few jurors, maybe there's not another group that's going to come in. You sort of meet and decide, hey, can we pick these last couple jurors, and then maybe we can get our panel going and start earlier. Again, that's just kind of speculating because it's the end of the day, but that's sometimes what happens when you get to those last jurors. And I think we're at number 11 already.